started here. We've got a couple of subs I'm aware of. Thank you, Cindy Howerton, for coming in. You can't hear. Can you hear now? Or I got the weak one. IT, can you kick it up any? Or here, I'm going to switch mics. How's that? That much better, much better. Thank you. Okay, we've got a couple of substitutes in here. Cindy Howerton, thank you for coming in. And I wasn't even aware you were coming. Care to introduce who you are and where you're from?
I'm Allison Hoagland, House District 15, covering for Tobias.
Swing your tag around there. No, okay, I don't need that one. Thank you for both for being here. Yeah. So we've got quite a bit to do today, so we're going to get moving here. First, I want to start with the approval of the minutes from February 13th. Do I have a motion? Representative Hoheisel, Representative Schreiber is a second. All for approval of the minutes, please say aye. Aye. Any opposed? Don't see any. Minutes are approved. Thank you very much. Let's get moving forward on opening up final action on House Bill 2589, authorizing public utilities and law enforcement agencies to enter into poll agreements. Nick, would you like to explain it? Thank you.
Yes, certainly, Mr. Chairman. So committee, this, as the chair said, 2589 would authorize public utilities, and this includes municipal utilities and electric cooperatives, to enter into poll attachment agreements with law enforcement agencies so that law enforcement agencies can attach and operate law enforcement equipment on utility poles. The poll attachment agreement under the bill has certain requirements, including that the agreement must identify the poles that the law enforcement can attach to, the nature of the equipment to be attached, the safety specifications for the attaching of the equipment, and a requirement that the law enforcement agent indemnify, defend, and hold harmless the public utility from all liability relating to the attachment. Public utilities can assess reasonable fees and costs for recovery of expenses incurred by the public utility for the attachment or maintenance or removal of those devices. And then also it would establish that a public utility is an instrumentality of a governmental entity under the Kansas Tort Claims Act. And then it also has another requirement for indemnification, stating that if a law enforcement agency is held liable for any claim relating to their activities, that the law enforcement agency shall indemnify the public utility for all claims arising out of that attachment. And I'll be happy to take any questions if there are any, Mr. Chairman.
Committee, any questions for the reviser? Okay. Representative Smith.
Thank you, Mr. Chair. We talked this morning, Mr. Chair. Nick, if are they going to put a electric box on there to show how much electricity they're using, or are they going to do solar? And if they do use an electric box, will the person that owns the pole hook it up, or just?
I think those are good questions, and the way the bill is structured at this moment, that would all be subject to the agreement that is between the public utility and the law enforcement agency to determine whether there's a needed electric supply, how that device will be powered, and who's attaching or not attaching that device.
Thank you. Thank you, Mr. Chair.
Any other questions? Okay. Nick, does this bill have anything to do with data retention, with anything with servers, or what are we specifically doing here?
This is only dealing with the agreement between public utilities and law enforcement agencies to attach equipment to utility poles. It's not dealing with the law enforcement activities that are conducted pursuant to those devices. So in essence, it's not dealing with the data that law enforcement may be collecting with those devices.
Thank you. I don't see any other questions. Committee, the floor is now open for discussion on House Bill 2589. Do we have any discussion? Yeah, if you want to, go ahead.
Thank you, Mr. Chair. I move that the committee pass out HB 2589 favorable for passage.
Got a second over here with Casey O'Hollison. Thank you. Discussion. Representative Hoheisel.
Thank you, Mr. Chair.
I'm sorry. Hang on. Sorry. Okay. Go ahead, Representative Proctor.
Right. Thank you, Mr. Chair. So I'm going to be voting against this bill, and I wanted to take just a second to explain why. I have no doubt that the Wichita PD is doing everything above board, and that they're going to use this data exactly as they explained to us they would. However, the data is going to be out of the state. The data is going to be in some cloud server in Washington State or someplace. And I really think that we as a body, as a legislature, we need to put some guardrails in place about how this data can and cannot be used. And so, frankly, I'm going to vote against this because I want to slow down this train. I think this proliferation of license plate readers and surveillance cameras with the data held outside the state where anybody, federal government could get their hands on it. I think that we are not on a good path, and we need to create some regulations around data sovereignty. So I'm just trying to slow down the train. I have no issue with putting these cameras out. I have no issue with the use of them for law enforcement purposes. I just think that we need some guardrails for data sovereignty. So I'll be opposing this bill. Thank you,
Thank
Mr.
you,
Chair.
Representative. Are you able to show me in the bill where it has data retention, cameras, etc.? This is a bill to indemnify the owners of the pole.
I completely understand. I'm trying to slow down the proliferation of the cameras, and if this throws a wrench in it until we can get some legislation written that does address those things, that's why I'm voting against it.
I'm going to go to. Can I go to Mr. Carmichael next? Let's see what you got to say there.
Thank you, Mr. Chair. I echo and agree, echo the remarks of and agree with my colleague from Leavenworth. And while this bill does not specifically address the advisability of these cameras, or as the chair points out, matters involving where data is stored, the bigger policy issue is whether or not the additional security that we receive from having 300 cameras in Wichita, Kansas, observing our every action, some of them surreptitiously, is the safety given to us by that program worth the infringement on our own personal privacy? Is it worth creating, in essence, 1984, where Big Brother sits in a room with hundreds of screens? Those screens are down at Sedgwick County Emergency Communications, by the way. I'm sure they'll give you a tour. But we haven't had a policy debate on that topic. The police department in my town and in multiple other communities has adopted either the Flock system, the Motorola system, or one or two competing systems that are out there without a serious discussion by this legislature about our rights to privacy and whether we want to live in a society where we're under constant observation of the police. And this is the vehicle, as my friend from Leavenworth says, that can be used to slow this process down so that we can have a policy debate about whether we as citizens of Kansas collectively want to live in that type of a world. And it's not constitutionally prohibited for the law enforcement agency to do what they are doing. The doctrine is very clear that anytime a law enforcement officer is in a position where he or she is legally entitled to be, they're entitled to see whatever they can see. And the doctrine has been expanded to say wherever their surrogate, if you will, the camera, is legally located, it can see whatever it can see, including your backyard. And so this is a chance, as the Colonel says, for us to slow this down. There is a second concern that I have with this legislation, and that is mixing the Kansas Tort Claims Act with private corporations. I'm not aware of another circumstance where we have mixed the government's waiver of sovereignty in the Kansas Tort Claims Act and now extended that to a private corporation. I think we're going to see an amendment here in a few minutes that changes a little bit of the language and puts in indemnify and defend, which is in fact the appropriate thing to do. And what that means is the law enforcement agency must pay for any damages caused by and pay for the defense and or provide the defense of any claims that might be brought against the utility because of a camera that's been installed by a third party, even like the vendors of the camera company called Flock that we have in Wichita, as well as one other. But to start handing out immunity, in essence, under the Kansas Tort Claims Act to private corporations is a bad precedent. I had indicated to some people last night that I intended to vote no on the amendment that is floating around here, and I'll just get this out in the interest of time. I am concerned that while the utilities involved have come to an agreement that appears to be acceptable to them, we haven't heard from the public about that agreement, and we haven't heard from the IBEW, the electricians union, who has to climb these poles and who will confront these cameras. And if you look on Flock's website, you won't be very impressed with this. They literally install these cameras with a big radiator clamp, a metal radiator clamp like you screw on, that they wrap around the pole. And I'm not sure that we've taken sufficient steps for the safety of line workers and others, not to mention the public, when one of these cameras falls off and hits them in the head or crashes through their windshield. I'll vote for the amendment, though, because I think it makes a bad bill better. Thank you for indulging me, Mr. Chair. I appreciate the time.
Thank you, Mr. Carmichael. Representative Holheisel.
Mr. Chair, is this an appropriate time to offer an amendment?
Yep.
I do have an amendment. It is not the one that my friend and colleague from Wichita was discussing. As Nick passes it out here, Mr. Chairman, if I may.
If you'd like to explain it. Go ahead.
This is just changing basically may to shall and from authorizing to requiring. I feel that when we have may in legislation like this and we leave it up to the utilities to pick and choose which poles or which neighborhoods these cameras can go into, I think that opens them up to, thank you so much, for a little bit of subjectivity in there. So if the law enforcement agency does request, they shall put it on the pole, and that puts it up to the law enforcement agency to pick and choose which ones, not the utility. So with that, Mr. Chair, I'll stand for any questions.
Is there questions on the amendment? I know we're still passing some out. Pardon? I've got one. All right. Representative Penn.
Excuse me. I see this right. The only question that I have is if you make the language stronger, going from may to shall. I know that this was brokered or agreed upon. Is there any opposition from your communications with the people who came in on this? Do they support this particular language?
I don't want to say they support it. I will say that they don't necessarily oppose it. So I don't want to put words in any of the utilities representatives that I talked to's mouths, but there was at least no opposition or strong opposition. So I would say neutral on the amendment.
And thank you, Mr. Chairman. I appreciate that. And I would be in support of this amendment. Thank you, sir.
Okay. Representative Carmichael.
Is this the appropriate time for discussion of the amendment, or do you only want questions?
I prefer questions at this point.
Okay, I will await a later opportunity.
Okay. Any other questions? Okay. Representative Smith.
Thank you, Mr. Chair. My thoughts were on the bill, so I'll wait till we
Okay.
come back to the bill.
Okay.
Thank you.
Thank you. All right. Is there a motion on the amendment then? Representative Holheisel. moves it, and we have a second from Representative Penn. Now go ahead, Representative Carmichael.
Thank you, Mr. Chair. I'm sorry that I was premature. This is not a good idea. First thing is, these poles are private property. They belong to the utility. We shouldn't be forcing them to put devices on their poles. Now, an argument can be made, but they're in the public right of way and they have a public service function, etc. But we understand that there's peril to their employees by doing this. There's peril to their employees because of the safety concerns I mentioned a few moments ago. There's also peril to their employees because in some circumstances, some communities, including mine, one of frankly the whitest communities in Wichita, there's going to be people who don't want the police department to have a camera peering into their backyard from the utility pole down the street. And we should not force the utilities to be the agent, if you will, of Big Brother. And I don't think this is a good idea at all. So I certainly hope members will vote no on this amendment and try to limit the damage that will be caused by the enactment of the base bill.
Representative Hoheisel.
Thank you, Mr. Chair, if I may just reply to that. I think that's kind of the basis of what I'm trying to get at. If you give the public utility the power to say we're going to reject the request to put these cameras up in your predominantly white neighborhood, but there's no lobbying power to lobby that utility to say we're going to refuse this to an African American neighborhood, predominantly African American neighborhood too. You're opening up that utility to accusations of discrimination. So this is saying, hey, the law enforcement can request if it's a white neighborhood or African American neighborhood, low income neighborhood, high income neighborhood, that they have to put them on each and every one as the law enforcement requests. That way there is no, okay, we'll put these in these perhaps lower income neighborhoods, high crime neighborhoods. But when law enforcement comes and requests to put them in Riverside or my area in my district, we're going to reject that just because it's a high income neighborhood. It's a predominantly white neighborhood. So this is just making sure that there is no accusations of discrimination within the utility.
Okay, I will let Mr. Carmichael go with the next one, and then
just briefly, the cure for discrimination is not to violate everyone's rights so that it's equal and fair. This is a bad idea. Thank you, Mr. Chair.
thank you, Mr. Carmichael. Representative Penn.
Thank you, Mr. Chairman. When we're here in Topeka, where we have the Brown versus Board of Topeka Education down the street. Bottom line up front is back when one of my distinguished fraternity members was arguing that case before the Supreme Court, Thurgood Marshall became a Supreme Court justice. And one of the things they argued before the Supreme Court is, what is it that equality is? And it means getting the same thing at the same time in the same place. In the African American communities, they see an exploding rate of crime, and WPD statistics as well as KBI bears that out as well. We know that, as I asked when we were hearing this bill, there's no expectation of privacy when you're in public space, which is where these polls that the utilities have agreed to with this bill and brokered, as well as the WPD coming into this space saying that this is something that they need to do. The police functions of the state to provide that same time, same place, equal protection under the law, looking in the backyards or the front yards of any of those Black constituents that we have in those Black neighborhoods or in the whitest neighborhoods as well. I would say that this is a good amendment that makes sure that everyone has equal protection and equal application of the law, getting the same thing at the same time in the same place without discrimination for the needs of the citizenry, which is to make sure that they are safe. Black folks want to be safe too. Thank you, Mr. Chairman.
Thank you, Representative. Representative Howard-Camp.
Thank you, Mr. Chairman. So I think the comments about private property have a lot of weight to require private property to put on police surveillance mechanisms. I just looked up which amendment is this. Third Amendment in the U.S. Constitution. This might be a slight stretch, but it's securing the perfect enjoyment of that great right of the common law that a man's house shall be his own castle, privileged against all civil and military intrusion. This is kind of just a write-up on I think the U.S. Congress Library website. For me, this is just going against some basic constitutional rights of private property, and for me, that kills the bill. Thank you, Mr. Chairman.
Representative Smith.
Thank you, Mr. Chair. If I could, just going back on the bill itself, I thought we were taking pictures of license plates, not so much of the whole area and backyards and so forth. Am I right in saying that, or am I wrong in saying that? Thank you.
I don't think we can answer that question. We don't know what equipment they're putting out there on these poles.
Thank
But is there further discussion? Representative Carmichael.
In answer to Representative Smith's question, you'll recall that Chief Sullivan described two different types of cameras. One is the flock camera, which is a license plate reader, which was the majority, I think, of the discussion. But the other half of those cameras are surveillance cameras, sometimes described as pole cameras. If you drive down the street, you can sometimes see them up above the intersection and that are looking down on you. Those cameras are not reading license plates. They are looking at vehicles, faces, etc. And quite frankly, they've been used to, for example, apprehend the murderer of George Tiller. So I'm not saying they're not without value, but I'm saying I don't want one of those put on the Evergy pole in my backyard, where they can look not only in my backyard, but my neighbors and everybody up and down the street. That's my problem. Thank you.
All right. Further discussion? Representative Smith on the second time.
Thank you. Just a thought. The DOT a lot of times will put cameras above the stoplights to observe what's going on. So the cameras are already there in some places. So I don't see I think the bill does more good than it does anything.
Okay, and we still are on the amendment. We're not on the bill. So
Thank you. Thank you.
all right. Representative Hoheisel, would you like to move?
Thank you, Mr. Chair. I close on my amendment.
Committee, you've heard the amendment offered by Representative Hoheisel. Anybody in favor, please say aye.
Aye.
Those opposed?
No.
Could we have a hand count, please, of those in favor? 1, 2, 3, 4, 5, 6. 6 in favor. Those opposed? 1, 2, 3, 4, 5, 6, 7, 8, 9. Amendment fails. Would anybody like their votes recorded? Representative Carmichael would like his vote recorded as a no, and Representative Penn would like his vote recorded as a yes. I'm sorry. Representative Smith as a yes. Anyone else? Okay, is there further discussion? Representative Turner.
Thank you, Mr. Chair. If it's appropriate, I'd offer an amendment. I believe the reviser has a copy that he can distribute.
Would you like to try to describe, or would you like the reviser to describe this one?
I'll describe it. I was going to hopefully let the folks have a copy of it to walk through it. It's
Fine.
somewhat lengthy.
Okay.
Has everybody got?
The amendment's being passed out. The floor is open for questions on it at this point.
Well, let me take a
Go
stab
ahead.
at walking through it. Like I said, it's somewhat lengthy, and as you remember in the original hearing, this bill, as we heard it, was a negotiated product from the Wichita Police Department as well as from the utility that serves that area, which is Evergy. But as written, it would apply statewide to all owners of utility poles, which that brings in the municipals as well as the co-ops. So, as well as cities that may have specific concerns. So these amendments proposed here would kind of increase, I think, and make this a better bill and address some of the questions that were left on the table that we heard in testimony. So just to start off, at the beginning, so in section 1, it makes it clear that this would authorize law enforcement agency to attach, access, operate, and maintain, whereas the original language only mentioned operating. So we're just expanding that to say attach, access, operate, and maintain or remove. So the full range of things that could happen to this particular device. And then going a little lower, section or item 2 there says that it would specify the nature of law enforcement equipment to be attached, including but not limited to the size and weight of the equipment. And then the amendment would say where on the poles the law enforcement equipment would be installed. And then it says something about power supply. The question came up in testimony about, will this require electric service? So that amendment says now, does it require, and whether electric service is needed. Any other provisions relating to the safe installation and use of the equipment? So installation and is added. And in the next section, establish the utility safety, and it just says and security specifications. These are the things that would be in the attachment document. Again, maintaining is added just to say it's not just the operation, but it's the maintenance, the putting up and taking down. And then there's a fairly lengthy attachment A that would be moved in here on item 4. Attachment A basically says provide the public utility the sole discretion to require that law enforcement equipment be attached, accessed, operated, maintained, and removed by the public utility or a contractor of their determination. So this is basically saying either the utility or a contractor approved by the utility would do the installation, maintenance, removal, and of the equipment on the pole. Okay, so to the point made earlier, you want to make sure that you've got qualified people doing this work. So once you get through A, then we go back to the front page and we go down and we have an insertion of attachment B. Attachment B says a pole attachment agreement may contain other terms, conditions, or provisions that are reasonable or necessary to facilitate the pole attachment agreement or to protect the public utilities systems infrastructure. So this basically allows, excuse me, for terms to cover kind of the unknown. So in other words, this leaves provision that as we go forward and things are determined that need to be specified in these agreements, that they can be. So moving on then to the next group, basically says, again, attaching, accessing, operating, maintaining, or removing, just expanding the language from just the original operation. The public utility shall not rent. So in other words, they don't charge law enforcement for the use of the space required for this attachment. Okay. Public utility shall not charge law enforcement agency for the use of space for the attachment of and then it goes to attachment C. I'm sorry for the roadmap here, but as we go to C, there's a big block of language there that basically is clarifying that it is the responsibility of the law enforcement agency to confirm that all the equipment that is installed complies with applicable laws. So that doesn't fall to the utility, but it falls to the law enforcement agency that they warrant and guarantee the public utility that they're following all required rules. I'll save you having to read that whole thing, but then as we go to the back, there's a few other insertions here. So basically, that law enforcement agency shall indemnify, defend, and hold harmless, as was mentioned in earlier comments. This expands that they will defend and hold harmless the public utility for any and all reasonable costs, expenses, including but not limited to attorney's fees that are associated with, and then it goes into one, claims arising out of the attachment, court actions. Let's see. So then it also inserts access, operation, maintenance, or removal of law enforcement equipment conducted pursuant to such agreement, including but not limited to claims or actions relating to crossing, removing on private property, or the public right of way. And then item 2 would be damages to utility systems or infrastructure caused by law enforcement equipment. So basically, those are the 2 provisions here. We've got a 1 and a 2 that is inserted. And then finally, it talks about right of way, and it just defines further that public right of way does not include a public or private easement that has not been designated as a public right of way. So a lot of language there, but like I said, the general purpose of this is just to expand it to make it language that can apply to various owners of these poles across the state. And with that, we'll take questions.
Okay. First off, is there a motion on your amendment?
Yes, I move adoption of the amendment.
We see a second from Representative Holdheisel. Now, committee, its amendment is open for discussion. Representative Carmichael.
Thank you, Mr. Chair. I do want to call to the committee's attention one thing about this amendment that is an improvement. And there are some good things in this amendment, but I had mentioned earlier about you want a camera on the pole behind your house looking into your backyard. The language that was just mentioned by the vice chair about public right-of-way, I think what that would say is it won't be on the pole in your backyard if it's between your house and your neighbor's house behind you, because that's not public right-of-way, that's an easement. But if the pole is located, say, like at my house, one house to the north out on the street, then they can put the camera there and use what's called a pan tilt view camera and spin around and take a look in my backyard to watch me pet my dog. And so, and I love my dog. She's sick right now. But at any rate, what I want to make sure we understand is if you stand in your backyard and you see a pole that's right there between you and the person behind you's house, they won't be able to put one there. But if you stand in your backyard and you can see the street light pole in front of your house, or if you can see the transformer that's at the end of the block there on the street, that is public right of way. And they'll be able to put a camera there so that if you can see them, they can see you. So this is an improvement. Thank you.
Other discussion? Representative Schreiber.
Thank you, Mr. Chair. This question is actually for Nick. I think it gets to the right-of-way issue that the previous member spoke to. So he's correct as far as if you don't have an alleyway in the back of your house, then it's not a public right-of-way where those poles are. But in my neighborhood, it doesn't have an alleyway, but on each property, there's a utility easement, which the utility can use to get back to those poles that are running back behind my house. Would those utility easements be considered? I don't think they'd be considered public right away, because then you'd have people walking all over your backyard, but I just needed a little clarification on that.
So I think this this does not include language would provide that type of easement would not be included within the public right of way definition. So any poles that are on essentially an easement that's not designated as public right of way would not be included and subject to this. pole attachment agreement.
So my question would be then if, and I'm maybe getting too far in the weeds, but if the operator of the camera, whoever that might be, if it's the vendor or law enforcement, whoever, then they would have to walk the distribution line behind people's houses to get to the, if, well, they wouldn't be in the camera. They wouldn't have the camera. That's right. Yeah. Yeah. Okay. I'm winding myself around the wheel here. So, okay. All right. Thank you. Thank you for clarification.
Further, or Nick, do you have any more? Okay. Further discussion? I do not see any. Representative Berquist.
I just want to thank whoever did the work to prepare this amendment. That helps me a lot.
All right. Representative, would you like to close on your amendment?
I close.
Committee, you've heard. All in favor, please say aye.
Aye.
Any opposed? Or amendment passes. We're back on the bill again. And Representative Carmichael would like his affirmative recorded. Okay. Other discussion? We're back on the bill. Representative Melton.
Thank you. Thank you. As a point of clarity, I'm looking at my notes. Somewhere it indicated that the utility workers don't install or maintain. Is that not accurate?
That would be a question for Nick, if you could.
So with the way the bill's sitting now with this amendment, it is the sole discretion of the public utility. So you on that attachment A on that amendment that was just adopted, it is the sole discretion of the public utility as to how that equipment will be attached, accessed, operated, maintained, removed. So they can choose whether their workers will do it or contractors approved by the public utility will be doing it.
Further discussion? Representative Smith.
Thank you, Mr. Chair. I was just thinking earlier, as I drive down the turnpike and I don't pay my toll, they take a picture, and as I get to the other end, I stop and say, hey, I messed up. And they have my license, they know who I am, they know everything. So I just think this is a positive bill that could help a lot of people. Thank you.
Representative Auerkamp.
Thank you, Mr. Chairman. Maybe a question for the revisers. So if one of my delivery trucks drives in somebody's yard, tears up their lawn, runs over their bushes, destroys their sprinkler system, I get to write a check to that homeowner. With the writing of this bill and with the amendment, how does it work if a public utility chooses to install the equipment, ends up driving on private property, tears up landscaping, lawns, sprinkler systems, fences, the list can go on and on. What happens next?
So I don't want to get into too many hypotheticals, but this, I mean, the only operation that can occur under these pole attachment agreements is within the public right of way. So it has to be within public right of way areas. So the utility shouldn't be going too far onto your land unless there's some reason they would have to access the public right of way from your property. But essentially, the indemnification language would provide that there'd probably be law enforcement being required to indemnify and hold harmless a public utility for actions relating to the installation, removal, maintenance of those devices.
Go ahead.
So homeowner has no recourse for compensation, recovery of losses. What's the homeowner going to do? Because right in here it says claims or court actions related to crossing or remaining on private property to access public right of way. They might be rare, but I know just simple deliveries, we end up with a lot of situations.
Yeah, so I mean, the homeowner should, if damage occurs to the homeowner, they should be reaching out to the public utility to or the person who caused that damage, and then potentially getting an attorney to advocate on their behalf, uh, and and seeking damages.
One less. But doesn't this hold them harmless? The people who cause the damages?
It requires law enforcement to indemnify and hold harmless the public utility for the actions relating to the law enforcement equipment. So, so essentially, probably what would happen is they'd all be sued and brought into a court case, or you'd have some additional plaintiffs being brought in from a defendant or something like that, or an additional defendant being brought in from another defendant, and it would get settled in court, and the court would be dealing with assessment of damages and who is indemnifying and paying for damages and things of that nature.
Sounds great. Thanks. Thank you, Mr. Chairman.
Representative Neighbor.
Thank you, Mr. Chairman. If there aren't any other questions, I would like to move that we pass out House Bill 2589. Favorable as amended, but he has a question.
Yeah, I appreciate that. I'm gonna wait and have one more question here from Mr. Carmichael.
I apologize. I was going to comment on the prior question, but we do probably need a motion, and then I can address it in discussion on the motion. That was my procedural error.
That's fine. Rep. Neighbor, would you please restate your motion?
Thank you, Mr. Chairman. I would move that we pass out House Bill 2589 as amended favorably for passage.
Thank you. Do we have a second? Representative Holheisel seconds. Did you have a question, Mr. Carmichael?
I had discussion on the motion. Okay.
Discussion, I'm sorry.
And now I'd like to refer to the question of my colleague that was asked just a moment ago. Mr. Meyer's explanation, I think, is correct, but as always, is correct. But public right-of-way arguably includes the area between your sidewalk and the street in front of your house. And so, as my good friends from Kansas Gas can tell you, that in my neighborhood, there's a lot of damage being done in the public right-of-way as they replace the natural gas lines. But it's my front yard, and they're going to fix it. They're really great about doing it. And if you ever have any trouble at all, you call them and you'll be a hero to your constituent because they take care of things. But if in the installation or maintenance of this camera on the public right-of-way, the crane, the tractor, the lift, whatever it is, drives into your front yard between the sidewalk and the street and puts ruts out there, it's going to be a mess then to figure out who is responsible to fix that damage in the public right-of-way, but in your front yard. Because we've confused the Kansas Tort Claims Act with general principles of tort liability. I think what's going to have to happen is that your yard's going to be torn up. You're going to call the telephone company, the electric company, or whatever, and say, there's a mess in my front yard, fix it. They're going to say, sorry, you got to call the city because it's because of one of their cameras. And then you're going to end up, by the time you get a lawyer, it's going to be right up against what's called the statute of limitations. And your lawyer is going to think, well, I just go ahead and sue the utility or maybe even the city. And then you're going to find out that you didn't make a claim under the Kansas Tort Claims Act in time. And you're going to end up with your lawsuit thrown out of court. We're going to end up with a situation where it used to be you just call up the natural gas company and Patrick takes care of it. Now it's going to be a situation where Evergy's going to say, well, it was our contractor that did it. It was our pole they did it on, but we're not responsible because the police department asked us to put the camera up. And then you're going to find out it's all subject to the requirements of the Kansas Tort Claims Act, which require notice of lawsuit and a number of other things. And in the end, you're going to have to get out there with your own shovel and fill it in and plant your own grass in your front yard. Or it's going to be a holiday for lawyers because there'll be 3 or 4 of us working on what used to be a simple call to the utility. Thank you.
Okay. We have a motion. I'm going to call for a vote on that. Everybody in favor of passing House Bill 2589 favorably as amended, please say aye.
Aye.
Any opposed?
No.
I see 2 noes, so the motion or the bill does pass. And Representative Carmichael would like his recorded as no. Representative Penn is a yes. Any others? Representative Smith as a yes. And Representative Melton, were you a yes? Correct. And Representative Berquist. Keeping up, Mindy? Okay. Okay. Yep. All right. Moving on. Okay, committee, I'd like to now take up House Bill 2690, the E911, abolishing the coordinating council and establishing the 911 board. Nick, would you like to explain?
Yes. So quickly, committee, I won't cover the whole in detail brief of this, but this House Bill 2690 essentially would enact some new statutes and then amend existing statutes within the Kansas 911 Act to do certain things. One is to authorize counties to contract with other counties for the consolidation of PSAP services, public safety answering point services. The second is related to that, to authorize distributions of 911 fee monies to those counties who consolidate their services so that they can use monies for that consolidation and pursuant to the contract with another PSAP. The third thing related to that is require that those monies that are distributed to counties be used and reviewed in accordance with the Kansas 911 Act. And then the last 2 large items are revising the state's 911 governance structure to, as the chairman said, abolish the 911 coordinating council and establishing a new state 911 board with a couple of additional voting members. And then lastly, require that all the monies that are collected from the 911 fees and the prepaid wireless 911 fees be transferred over to the state treasury, and all the current funds that are outside the state treasury be moved over to the state treasury effective on January 1 of 2026. And I'd be happy to answer any questions, Mr. Chairman.
Hey, committee, any questions for the reviser? Not seeing any. Do I have a motion? Representative Turner.
Mr. Chairman, yes, I move that the committee pass out HB 2690 favorable for passage.
Do I have a second? Representative Hoheisel seconds. 2690. 2690. Thank you. And Representative Hoheisel.
Thank you, Mr. Chair. I do have an amendment on this bill as well.
Hold on. Go
I
ahead.
do have an amendment on this bill as well.
Right. Yeah. So the committee 2690 is now open for discussion. Representative Hoheisel.
I have an amendment.
Okay.
This amendment was requested by Ed Klump in his testimony. I'll let Nick explain a little further. I can say I have not talked to my colleague from Wichita, who's a co-sponsor of this bill, to see if he's given a thumbs up in the affirmative. I did talk to Representative Hoffman the other night, the other co-sponsor on this bill, and he said he was fine with this amendment. So.
Go ahead, Nick.
So committee, what this amendment would do is it would, this would be in the new state 911 board. I might have said too many ones there. So with the new board, not for the council, so effective July 1, 2025, the state 911 board would be authorized to increase the minimum county distribution amount. If you recall, effective in this bill, July 1 of this year, 2024, the minimum amount would be increased to $70,000 from $60,000. And then once the new board gets installed, This would authorize the board to increase that minimum distribution amount and then set kind of a limitation on that increase. So the increase couldn't essentially exceed the inflation amount as determined by the Consumer Price Index for urban consumers in the Midwest region for the prior year. So it essentially is whatever that minimum amount is multiplied by the Consumer Price Index, and then that's the increase that could occur each year. Prior to undertaking this increase, the proposed amendment in front of you would require the state 911 board to evaluate whether that increase is needed based on the expenditures of the counties who are subject to that minimum amount, and then also the impact of increasing that minimum amount to the long-term financial stability of the other distributions that are made to PSAPs and counties pursuant to the distribution schedule that's provided in the 911 Act. And I will note, committee, if this amendment does get adopted, Section 25 of the bill, and you can see on the second page or the second kind of balloon there, Section 25 of the bill would be in the committee report stricken in whole and then reinserted with the new language engrossed and included within the new language that would be adopted. And then all the revisions that you see within Section 25 would essentially be redone. And this is strictly because it's kind of, there's a couple of effective dates that are happening here. So this is just kind of a technical thing that will happen in this committee report if this amendment gets adopted.
Any questions for the reviser? Representative Neighbor.
Thank you, Mr. Chairman. Nick, does this just kind of give there's a percentage that they can go up, but doesn't this just give them an open ceiling to a certain point, and without reporting back to us on what they have, maybe we need some oversight as to how much they have in their account, because it was pretty hearty when we heard it. I thought 42 million when we heard the bill. I just would hate to see this go in excess or get away from us. So it's just a question.
So the amount of the fees that are collected wouldn't be changing here. So the collections that are occurring would be the same, and the council or the board has the authority to lower that fee. This strictly gives them the ability to increase that minimum distribution amount to counties. And then they have to do that kind of a consideration of the long-term financial stability of ensuring that those distributions continue to occur at the statutory amounts and ensure that the minimum distribution increase doesn't affect future distributions to PSAPs and counties. And then kind of evaluate whether that type of increase is needed and warranted for those counties that are subject to the minimum. And it does provide that cap of the inflation amount in once per year. I should have mentioned that when I described it, Mr. Chair and committee members. The state 911 board may not increase it more than once per year by that inflation amount. So they could do it at a meeting only once per year.
Thank you, Mr. Chairman.
Yeah. Any further questions for the reviser? Not seeing any. Do I have a motion on the amendment? Representative Hoheisel makes the motion, and Representative Penn is a second. Committee, the amendment is open for discussion. Representative Carmichael.
Thank you. Very quickly, the total amount of the fee that's on your phone bill, the 911 fee, is set by the legislature. In fact, the chairman was very instrumental in cutting that request literally in half several years ago. So the legislature limits the total amount that can be collected. The board and or the council can reduce that assessment. In other words, it's up to, I think it's 90 cents now. But what this really does is this hopefully helps address the concern of Mr. Michaelis, who testified in opposition, because there is a concern by some that this is a subterfuge to actually reduce funding to the local PSAPs or the local distribution points. Rather, there is an excess of funds right now in the account, and there's a need to get more money out to help these PSAPs that are having to consolidate now and a number of other things. And so law enforcement came up with a good idea and said, let's authorize the council to go ahead and get that money out there in the field rather than holding it in the bank somewhere. And so I hope that this makes this bill a better bill, and I intend to support it.
Further discussion? Not seeing any. Representative, would you like to move your amendment?
Thank you, Mr. Chair. I close on my amendment.
Right. Committee, you've heard the amendment. Those in favor, please respond with an aye. Aye. Those opposed, amendment passes. Back on the bill. Second. Yes, could you please record Representative Carmichael? We're just going to pass it out real quick here. Thank you. Yep. All right. Committee, what's going on here? We've got a technical change. We had someone notice there was just an error on the name in here. And I'll let Nick explain it, but it changes the bill in no way other than to change a name. And Nick, when you're ready.
Yeah, thank you, Mr. Chair, and I appreciate the committee's indulgence. So, committee, this is what I would consider strictly a technical amendment. On page 2, you will notice it was pointed out that the Kansas Rural Independent Telephone Companies are no longer is no longer the entity's name. So that entity is now called the Communications Coalition of Kansas. So this updates that name to correctly reflect that organization, and as long as that is the correct movement of that organization, I'm comfortable calling that a technical amendment. There's a couple other on page 7 of the bill that you see there. There's just some technical amendments that were suggested by my fellow budget revisers regarding budgetary transfers. On page 10 of the amendment, you see it within the definition of local collection point administrator. Sherry Massey, who got up at the very end of the hearing and kind of spoke to you about some of the bill, and who Representative Carmichael pointed out that was very helpful, has been very helpful through this process. She pointed out kind of an issue with the definition of local collection point administrator, and I agree that it does need to be updated to just reflect that the new funds and just kind of make a change there to correctly reflect the definition of local collection point administrator. And then lastly, on page, you'll see at the very end of page 31 is another issue that Sherry pointed out. When the bill was struck some language in this section, it eliminated some transfers that were occurring to the 911 operations fund inadvertently. So this would reinsert those transfers back to the 911 operations fund. Essentially what happens is once the monies go out for distribution to PSAPs and counties, any monies that are not attributed to a specific PSAP or county, or I think that's the only, just kind of monies that still remain after that distribution. Those monies under current law are supposed to be transferred to the operations fund. So this continues that transfer to the operations fund with the new funds that are within the state treasury.
Okay. Committee, any questions for the reviser? All right. Do I have a motion on the amendment? Representative Neighbor.
Thank you, Mr. Chairman. I move that we pass the amendment, the technical amendment to House Bill 2690.
Do I have a second? I see Representative Roth is shown as a second. All right. Any further discussion on the amendment itself? Not seeing any. You don't see any, do you? Okay. Committee, you've heard the amendment offered by Representative Neighbor, I guess. Okay. Those in favor say aye.
Aye.
Any opposed? Amendment passes. Back onto the bill again. Any further amendments or discussion on the bill? Representative Neighbor.
Thank you, Mr. Chairman. I move that we pass out House Bill 2690 favorably as amended.
Okay. Do I have a second? Representative Roth. Okay. You've heard the motion. Those in favor of recommending House Bill 2690 as amended signify by saying aye.
Aye.
Any opposed? Bill passes. All right. And Representative Carmichael would like to show a positive vote. Any others want their votes recorded? All right. Let's move on to House Bill 2590, updating maximum penalties that may be imposed for by the State Corporation Commission for pipeline safety. Nick, would you like to explain that one?
Yeah, this committee, so House Bill 2590, again, as the chair said, would update the maximum penalties that can be imposed for pipeline safety violations from the State Corporation Commission. And generally, these penalties are updated to reflect updates that the federal government made to federal law relating to the pipeline safety penalties. And I think you heard KCC's explanation of why they believe this is something that's necessary for them.
All right. Questions for the reviser? Not seeing any. Could I get Representative Turner to make a motion?
Yes, Mr. Chairman, I move that that the committee pass out HB 2590 favorable for passage.
All right. You've heard the motion, and I have a second from my ranking member here. Committee, the floor is now open for discussion on 2590. Any discussion? Not seeing any. All right. Would you like to close on your motion?
I close.
All right. Okay, committee, you've heard the motion. Those in favor of recommending House Bill 2590, please signify by saying aye.
Aye.
Any opposed? Looks like bill passes. Representative Carmichael would like his vote recorded. Anyone else want their votes recorded? Okay. Moving on to 2591. Exempting the State Corporation Commission from the Open Meetings Act and prohibiting ex parte communications in all commission proceedings. Representative Neighbor.
Thank you, Mr. Chairman. I found the testimony to be very interesting on this and their inability to communicate in some sort of a fashion, but I certainly understand the law. I would move passage of House Bill 2591.
You heard the motion. Do I have a second? Representative Holheisel, I'm sorry, has a second. With that, is there any discussion? Representative Proctor.
Thank you, Mr. Chair. I'm going to support this bill. When at first blush, when I first saw it, I'm not a fan of less transparency or closing meetings, but the assurances from the commission that they will continue to hold public meetings on all of their policy decisions and the support of the industry that they regulate has persuaded me to reluctantly vote for this.
Okay.
Thank you, Mr. Chair.
And I will get to further questions. I'd like to have Nick describe the bill real quick here.
Yeah, as the chairman said, it's that short title does a pretty good description of it. I will note that the Kansas Open Meetings Act exemption only applies with respect to matters that relate to docketed proceedings in front of the commission. So anything that's docketed in front of the commission would not be subject to the Kansas Open Meetings Act, but would be conducted pursuant to the hearings and the docketed briefings in accordance with commission procedure and administrative procedure law. The prohibition on ex parte communications would prohibit ex parte communications in all docketed proceedings. So ex parte communications is defined and essentially is a communication between a member of a docketed proceeding or a party to a docketed proceeding and a member of the commission. So those types of communications would be prohibited unless that communication is done through an official docketed type of filing to the commission. The current law does already prohibit ex parte communications between parties and presiding officers for commission proceedings that are adjudicatory in nature. And again, this would prohibit those ex parte communications in all docketed proceedings. And I'd be happy to stand for questions.
Any questions for the revisor? All right. The bill is open for discussion at this point. Representative Carmichael.
Thank you, Mr. Chair. Good legislation makes for strange bedfellows. And while I'm not in bed with Representative Proctor, he and I are too closely aligned these days for comfort for either one of us. And I might also add the governor's office last night wanted me to brief them on this bill. I didn't have time. I hope they're listening. As Representative Proctor says, I think all of us have concerns about weakening the Open Meetings Act. But as Nick points out, as Mr. Myers points out, this applies to docketed cases. This is when the commission acts, in essence, as judges in what we call a quasi-judicial proceeding. And when you add to it the prohibition against ex parte communications, not only with the presiding officer, but with any of the decision makers in these docketed proceedings, that is important. And so I think this will be the right thing to do. There was one other point in this bill that was of import, but unfortunately, I've forgotten what it was. But it's a good bill. But we have to, just going to say, this obviously does not extend to the other things the commission does. When they're doing things that aren't adjudicatory, i.e. aren't on docketed cases, when they're setting budgets and those sorts of things, they're going to be like anybody else. It's just when they're acting in the role as judges that this really kicks in. So it's a good bill.
Thank you, Representative. Further discussion? All right. Representative Neighbor, would you like to move your motion?
Thank you, Mr. Chairman. I would like to close with that I'm glad the group came together and brought this to our attention, and I think it's a good time to make this change. And so with that, I move that we pass House Bill 2591 favorably.
Okay. Committee, you've heard the motion. Those in favor of House Bill 2591, please say aye. Aye. Any opposed? Bill passes. All right. Representative Carmichael would like to show that he is a yes vote. Anyone else would like their vote recorded? Not seeing it. I had 2597 on the list today. We are not going to work it at this time. There's still some discussion going on that one. So that does conclude. Is there any discussion, questions, or anything before we close the hearings on everything? Calendar moving forward. The last day this committee will meet is Tuesday, February 20th. Please watch the bulletin board at this point. I don't know if we're going to have a meeting or not, but we'll see with the further discussion on 2597 if we have to. So it will be just shown as on call of the chair at this point in time, though. But I truly appreciate everybody working with us during this portion of the session, and look forward to after turnaround doing it again. So thank you, everybody. We're closed.